Jody Wilson-Raybould is Canada's Minister of Justice, and she joins us from the House of Commons foyer. Minister Wilson-Raybould, earlier today, the Prime Minister emerged to say he must make sure this doesn't happen to another family. But I'm kind of curious what that means, because it suggests something wrong happened in the judicial system here. Was justice denied to the Boushie family, in your view?
Well, I'm really pleased today that not only did I and Minister Goodale get to meet with the Boushie family, but the Prime Minister did. And to hear them speak so openly about their experience is something that I will never forget. I think that it's important to recognize the hurt that they've felt, the experience that they have, but separate that from the broader question that I'm incredibly focused on, as is our government, which is broad reforms to the criminal justice system to address issues that have impacted Indigenous peoples from the beginning of our justice system in Canada.
Okay, but I want to go back to the point at hand here. The family certainly believes justice wasn't done here. Do you believe not having Indigenous representation on this jury denied justice to Colten Boushie?
Well, I think that we had a very instructive discussion with the family, and I'm wanting to answer your question. The family spoke about the necessity of transforming a system that has historically denied justice to Indigenous peoples. That's the source of speaking about how we can and must do better. The criminal justice system, the challenges for Indigenous peoples are reflected in the overrepresentation of Indigenous peoples in jails, of the overrepresentation of Indigenous peoples as victims of crime. This is the work that we are going to continue to do. We have been engaged on this since I became the minister, and there's been engagement on this before. With respect to your question on jurors, what the Colten Boushie trial and the outpouring of support for that family brings up and highlights is a national conversation about jury selection, about whether or not reforms are required, repealing the preemptive challenges that are in the criminal code. These are discussions that we're having, and the sad reality of the death of an individual has brought this to light, where not only are we having a conversation about jurors and the appropriateness or the composition of juries, but we're having the necessary broader conversations about what is required to make our justice system fairer and more equal for Indigenous peoples and other marginalized individuals in the country.
But as you say, they have a right to be tried by a jury of their peers. And I'm trying to figure out if that means Indigenous people should always have Indigenous representation on juries when they're victims or something. I don't know whether this would spread to other groups, whether Asian gang members have to have Asian representation, or Middle Easterners, or whatever. I'm wondering where the line is here. When is a jury fair and when isn't it, when it comes to its composition?
Well, I'm not speaking specifically on the jury in this particular case. What I'm talking about is the broader discussion around jury reform and how the federal government can inject itself in jury reform. We've benefited from, as Omar said previously, from reports from former Supreme Court Justice. There was a justice inquiry back in 1991 that spoke about what can be done. There are things that the federal government can do, but we have to continue to work with the provinces and territories on potential changes to jury selection, the pool of juries that are available. Individuals do have the right to be tried by a jury of their peers, and that is reflective of the communities across the country in provinces and territories. And this is a really important discussion that this tragic situation has highlighted, and I'm committed to addressing.
All right, so let's go back to the Iacobucci report that Omar was referring to. That was in 2013, and he identified what he called a crisis. And he said the problem is Indigenous communities don't trust the system, don't want to be part of it, and that they don't understand it. And I just wonder how you break down that distrust and fear of this system and make Indigenous people want to participate in the justice system? What has to be done?
Well, people have to, first of all, people have to trust the system, have to see themselves within the system. We can talk about juries and the composition of juries, but this is a broader conversation that we have to ensure that we look historically at the reality and the impacts of the justice system on Indigenous peoples, get at the root causes of why they feel marginalized from the justice system, get at the systemic barriers and realities that have impacted Indigenous communities when confronted with the justice system, and figure out ways that we can improve it so Indigenous peoples can see themselves within that system, improve on that system, look to measures that are more culturally appropriate. There's a lot that we can do. There's a lot that has been done. The Iacobucci Report speaks to specific realities and challenges that need to be addressed in the provinces and territories. And you have to remember that that was a report that was for the Ontario government. We can take lessons from that report and continue to have conversations with our colleagues in the provinces and territories.
All right. Minister, I appreciate you taking the time to talk to us.
Thank you.